All right. Good morning, everybody. Thank you so much for being here. This is an incredible turnout, and it's wonderful to see everybody showing up to this. I just wanted to quickly introduce myself. My name is Tayyir Perlman. I'm the lead staff attorney of the Rural Law Initiative based out of the Government Law Center at Albany Law School. We offer legal assistance to rural businesses and also do access to justice research on the shortage of attorneys in rural communities and the emerging needs of people living in rural communities related to the law, and putting together legal educational programming that serves those needs, including an event like today. This event was actually born at a legal educational event we did last year called Sustaining New York Farms, Legal Tools for Farm Business Futures. We had a session on bankruptcy law and other debt workout mechanisms for an hour, and we were very fortunate to have bankruptcy law Judge Diane Davis present at that time. And from there, responding to the number of questions that came from the audience at that event, we built this program here, which was really put together by Judge Davis and this incredible panel. In addition to Judge Davis right here, we have Peter Orville. Would you mind raising your hand, Peter, just so everyone, okay. So yeah, we have Peter Orville, and he's been representing consumers in bankruptcy law since 1989. We also have Patrick Radel, am I pronouncing that? Radel. Yeah. And he's been bankruptcy law, creditors' rights, and federal litigation attorney for many years as well. We also have Mark Swimler, right there. Am I pronouncing that right?
I go by anything close.
Swimler, okay. And he's a Chapter 13 trustee in the Northern District of New York. They're an incredible panel. All of them have wonderful background in this part of the bankruptcy code, and we're all very fortunate to have them here to teach us. One thing to note is that our legal educational programming is open to everybody, attorneys and rural businesses and people from the community, and I just wanted to get a show of hands. How many people that are here are farmers or farm families? Raise your hand. Okay, and how many people here are attorneys? Great. And how many people here are just members of the community that are looking to learn more about this? All right, it's really good, wonderful. I'm glad you're all here. This is like a nice mixed crowd. For anybody looking for Wi-Fi info, they're on the wall over there if you want to tune in and like download the materials. Also, throughout the program, if you have any questions, it's really important that you wait until a mic is passed to you. We need to record everybody's questions and make sure that it's clearly audible for the video recording. And myself and my colleague Clay Gustav are going to be running around passing out mics. So just wait until you get a mic before you ask your question. Anybody who's an attorney here looking for continuing legal education credit, you need to fill out these forms, which were handed to you by my work colleague Lisa in that back table when you first entered. So make sure to do that. And that's it from my end. I thank you all for being here, and I hope you enjoy the show.
Thank you very much, Tayyir. Let me just begin by saying it takes a village. I'm very grateful to have these gentlemen join me here today. They're all extremely busy people, but it couldn't be a better combination. I have a long-standing Chapter 12 trustee who administers all of the Chapter 12 cases for the Northern District of New York. So he takes care of cases as far west as Syracuse and as far right as Albany and all the way to the border and all the way to the border. So, and he's been doing this for a number of years, so he's got a lot of experience. Mr. Radel wears the creditor's hat, but he does it on a regular basis and is very in tune with the issues and issue spotting for Chapter 12 that he will discuss in detail. And Mr. Orville is a longstanding debtor's attorney. So you really have the breadth of experience and knowledge here. And while we have a Q&A at the end, if we are saying something or not explaining something well enough, please raise your hand, because we would like to nip whatever question mark you have above your head right out the gate. With that said, I want to follow up a little bit more. How many of you have ever filed a Chapter 12 petition? Anybody in the room? Okay. How many would consider themselves like a creditor of farmers? Okay. Okay. And so then the rest are perhaps lenders? Lenders, show of lenders? Okay. Okay. So we have a better idea. Our knowledge, besides the case law, and you've been provided a case law update for several years from 2012, which will literally walk through all the issues that we're going to talk about right now, is there for you to spring off of. But it's not just the case law, it's the bankruptcy code, the bankruptcy rules, and the local rules. Most courts have their own local rules. So if you ever find yourself needing to come into bankruptcy court, you're going to need to look at those resources in preparation of the same. With that said, Mr. Orville, Peter is going to talk a little bit about the history of Chapter 12.
Thank you. First, I have a couple other questions. How many people here work for the government?
Oh, good question.
Okay, and is that all farm service? What's that? Farm service agency. Good. And how many people here are from FarmNet? Anybody?
One.
Great. Okay. FarmNet is a wonderful organization, as is Farm Service Agency. Although some of my clients don't agree with that, but they are. Sorry. Okay, and again, how many lawyers are here? Can you raise your hand? Of how many of you have filed any bankruptcy cases at all?
None of them.
Okay. So, okay. So what I want to do is start by talking a little bit about the history of Chapter 12. Anybody here remember when Washington, D.C. was taken over by farm tractors back in the 80s? Farmers were real upset about a lot of things, and they protested by bringing their tractors and clogging the streets, thank you. Clogging the streets of Washington to make their point. At that point, in the late 1980s, land values were falling, grain prices were soaring, interest rates were tightening, tighter credit brought on at that point the worst crisis for farmers in the 20th century. And so besides driving to Washington, they had, you remember Willie Nelson and the Farm Aid. First Farm Aid was in 1985. Willie Nelson, by the way, if anybody happens to run into one of the new $100 bills, if you hold the $100 bill up to the light and you look at the little picture of the guy that's sort of hidden in it, tell me it's not Willie Nelson in that picture. If you get a chance, take a look at it. You'll see. I don't think it's supposed to be him, but I do think it is. So in 1986, Congress responded either to Willie Nelson or to the tractors in the streets by making a temporary Chapter 12 part of the bankruptcy code. It gave farmers a tool to reorganize their farms, their finances, with unprecedented power and efficiency. We now have what many are considering a new farm crisis in the country. Farm income from 2012 to 2016 fell over 34%, a $50 billion decrease. Decreases in livestock, milk, and crop prices, rising interest rates, increased debt, left many farmers unable to repay their debts. As I'm sure you're all aware, family farmers particularly are shrinking. There are many fewer family farms that exist, and a lot of people are concerned about the future of food in our country because there are fewer producers. In November of last year, one branch of the Federal Reserve Bank warned that low commodity prices and recent tariffs was threatening the viability of farms. And Chapter 12 filings are starting to rise dramatically. I think that's true here in upstate New York. It's also true throughout the Midwest. The number of Chapter 12s are increasing. I want to talk a minute, if I could, about bankruptcy. What is bankruptcy? Because nobody here has filed a bankruptcy as an attorney, and if any of you have filed as a debtor, then you know something about it. But bankruptcy changes, the law changes, and the practice changes. One of the most important things about bankruptcy is that when a bankruptcy is filed, immediately there is put in place what's called an automatic stay. Stay means prevent. Creditors are stayed from or prevented from taking any action against the debtor.
And that's by operation of law. There's no judicial intervention. It's upon the filing, right then and there.
So we file a case now by pushing a button, and magically it goes somehow it gets filed. And that second that it's filed, the automatic stay goes into place, whether you know it or not. You could be a creditor with a truck on its way to pick up the cows from a farm. The case is filed at, say, 10:30 in the morning, and your truck gets there at 10:45. The automatic stay is in place. Now, you may not know it at the time, and if you take the cows, you probably won't get in too much trouble, but you got to return them. And but the automatic stay is a very powerful tool in any bankruptcy.
And why do you have to return them? Because right at that time, at that moment, an estate, a bankruptcy estate, is created, and it includes all legal and equitable interests of the debtor. So that includes lock, stock, and barrel, real property, personal property. It's part of that bankruptcy estate, and that's what the automatic stay seeks to protect.
Thank you. So if you are on your way to pick up those cows and you get told about the bankruptcy, either because someone called you on your cell phone or the farmer is there saying, you can't do this, I just filed bankruptcy. If you then take the cows, not only are you going to have to return them, but you may be liable for violating the automatic stay. And that could include sanctions, it could include damages, and you may have to pay money out. So you've got to be very, very careful if you're going to do that. So what can a farmer do? There are, first of all, there are four different types of bankruptcy that a farmer can take part in. One is a Chapter 7. Chapter 7 is a complete liquidation. That's where they're saying, okay, we're done. And you look at the assets, you look at the liabilities. Secured creditors can then either get their assets back or their collateral, or the farmer can say, okay, I'm filing bankruptcy, but I want to continue paying for this car, this tractor, these cows, and work something out with the creditor. Or can just say, I'm going to liquidate. And then a Chapter 7 trustee gets appointed, and if there's any equity in assets, Chapter 7 trustee goes after that, liquidates it, sells it, turns it to cash, and uses it to pay off creditors in a pro rata format, where everybody gets the same percentage. That's a complete bankruptcy.
Correct, and the trustee steps into the shoes of the debtor. The debtor doesn't take any further actions. It's really for the trustee to administer the assets for the benefit of the creditors.
Now, here's a good example. In a Chapter 7, so let's say you are the squeaky wheel. You're the creditor who's pushing really hard to get some money from the creditor, from the debtor. And the debtor said, okay, fine, I need to make you go away. Here's $10,000 towards my, the amount of money that I owe you, some grain, some feed store or something like that. Then they file a Chapter 7. The trustee in the Chapter 7 may very well go to that feed store and get that $10,000 back because it's of preference, because they preferred that one creditor to all the other creditors. The trustee may take it back and then distribute it out. So keep that in mind if you're a creditor also, that may be in a Chapter 7.
What other chapters could a family farmer think about?
Well, I'm glad you asked. So there are 3 other reorganization chapters that a farmer can look to. One is a Chapter 12, which is a farm bankruptcy. One is a Chapter 13, which is a reorganization plan open to any individuals and or families. And one is a Chapter 11, which is a reorganization on a usually larger scale. Chapter 11 is necessary if you don't qualify for either a Chapter 13 or 12, and we're going to talk about that some more up the road. But those are the... Now, Chapter 12 has a little bit of a Chapter 13 in it and a little bit of a Chapter 11 in it. It's more user-friendly than a Chapter 11, and it's more powerful in what it can do than a Chapter 13. It's generally debtor-friendly, but creditors shouldn't be scared of that because there's a lot in there in the law that allows creditors, as my worthy opponent many times, Pat Radel, will tell you, there's a lot of things that you can do in a bankruptcy. And I just want to say, so I've got 2 kinds of cases sometimes. Some cases are strong cases. Some cases are kind of weak cases. So in a strong case, I like it when someone like Pat Radel comes in for the creditors because he knows how it works, he knows the rules, he knows how to do it, and we usually work things out. When I have a weak case, I don't like it when Pat gets in because he knows it's a weak case. I'd much rather have some attorney who doesn't really know much about bankruptcy because I can bully them. Not that I do.
I didn't hear that.
Not that I never did. But, okay, so the Chapter 12 and Chapter 13 are very similar in certain respects. One is that they both have what's called a standing trustee. Mark Swimler is the standing trustee for both the Utica Division and the Syracuse Division of the Northern District of New York Bankruptcy Court.
13, but he's
13 and
he's
12.
across the street.
Right, and Albany for Chapter 12.
Yep.
So it's the same trustee in both Chapter 13 and Chapter 12, and their function is much the same, as he will tell you, in terms of collecting money from the debtor and distributing it out to creditors. And the case proceeds in both a 13 and a 12 under the trustee's supervision until the end of the plan. Unlike a Chapter 11, where until the new law goes into effect for small business 11s in January, there is no standing trustee, and the debtor himself or herself is the trustee, the debtor in possession. And it completes much quicker, whereas in a Chapter 13 or 12, it's generally 5 years, sometimes a little less. Debts can be restructured. Secured debts can be restructured using what's called a till interest rate. So if you have a farmer has a 10% loan out there on a secured loan, they can change the terms of that loan in a 13 or a 12 to the till rate, which is 5-6%, something in that range now. And upon the completion of the plan, the debtor gets a discharge of any debts that were remaining that were not tied to security or survived the bankruptcy. So all unsecured debts that are not paid in the Chapter 13 or 12 are discharged, just like all of them would have been discharged in a Chapter 7, barring fraud. And in both a Chapter 13 and a Chapter 12, if things go badly for the debtor generally has an almost absolute right to get out of it. Can say, never mind, I'm done. Unless it's through fraud, that's a different story. But But a Chapter 12 has a lot of advantages over a Chapter 13, one of which is the eligibility. So the eligibility for a debtor to file a Chapter 13
Mark will talk about in detail.
is,
So
right,
So if you want to,
what's the number? It's around
10.
400,000.
what?
Chapter 13.
10 million?
No.
10
Chapter
million?
13. We're
Oh.
talking 13.
Oh, it's about 4.
It's about 400-ish thousand of unsecured debt and about 1 million or so secured debt. Whereas in a Chapter 12, up until very recently, it was like $3 or $4 million. Now it is $10 million because the Congress just, they don't do much down there, but they did just pass a change to the bankruptcy law. Yes. Question?
Yeah, I just have a quick question. Can you just clarify the distinction between secured debt versus
we'll get to that. We're
Oh,
just
okay.
trying to give you an overview right
Okay.
now. When Peter's done, I'm going to give you a timeline for Chapter 12, and then we'll get into each of those respective areas in detail, so we don't like mix it all up for you.
Okay.
But a quick answer, if I may, is a creditor can take something back if it's secured and can't take something back if it's not. There's something that we bankruptcy practitioners call the hanging paragraph, which I don't have to explain other than saying how dumb Congress is. But is that fair to say? I won't
I
ask
would
the
never
judge.
say
I won't
that.
ask the judge. But the hanging paragraph basically says that in a Chapter 13, you can cram down, you can pay the value instead of the debt of a vehicle or any other secured item. But if it's a vehicle and it's within 910 days, 2.5 years, you can't cram it down. In a Chapter 12, that restriction is not there. So you can cram down anything, which means cram down means pay the value, the current value of the collateral instead of the amount owed if the value is less than the amount owed. The other big tool in a Chapter 12 is that you can sort of redo any secured debt. So, say you have a mortgage and you owe $1.5 million on real property. And the real property is currently worth $1 million. So you can't in a Chapter 13, but in a Chapter 12, you can say, okay, we're going to redo this. We're going to make this, instead of owing you $1.5 million, we're going to owe you $1 million. And we're going to change the term of the note. Right now you have 15 years left on the term. We're going to stretch it out to 30, and sometimes with FSA up to 40 years left on the term. And based on the interest rate can go down to what a normal interest rate would be now. And again, that's another reason FSA, I think, is good, because their interest rates are way better than most bank interest rates for mortgages.
So let's talk about a little bit of where and when all of these benefits of Chapter 12 fit in. Hopefully, the debtor or debtors meet with debtors' counsel before it's too little too late. You know, hopefully the foreclosure isn't tomorrow or the auction isn't tomorrow. But with that said, the debtors' counsel will gather all of the financial information from a debtor. And that comes from many, many sources. It could be tax returns, it could be profit and loss statements, it could be prior lending agreements, etc. And meets with the debtor and assembles the petition and the schedules. And the schedules list by the type of debt that the debtor has. So somebody asked about secured debt. It means it's secured by collateral. And a secured creditor has, in the scheme of things, superior rights. Or it might be taxes due and owing. They're called priority debts. And we'll get to that about, it's sometimes very important to time a bankruptcy if you have that luxury based on when taxes are due and owing and how old they are. And then, unfortunately, last on the rung are the unsecured creditors. And they are typically the tradesmen, and there's nothing, quote unquote, securing their debt. It's an ongoing exchange. But the Debtors Council collects this information and files the petition and schedules with the bankruptcy court. The debtor pays a filing fee to file that petition. And as Peter indicated, the automatic stay immediately goes into effect without judicial intervention. Approximately 21 to 35 days later, and this is done through the clerk's office, a meeting of creditors is scheduled. And at that juncture, Mark, the debtors will appear before Mark as trustee, who puts the debtor under oath and examines the debtor about the financial information in their schedule and petition, and likely will ask about, providing information, etc. Within 90 days of the filing, the debtor has to file a proposed Chapter 12 plan. In other words, this is how I'm going to take care of my various creditors in bankruptcy. It's set down for a hearing on notice to the creditors on the matrix. They're part of the schedules, and goes to a confirmation hearing, which is supposed to end in 45 days, but oftentimes it gets extended if the parties are working things out or need to file, the debtor needs to file an amended plan. Creditors can object at this point. This is a difference from a Chapter 11. In other words, in 11, the creditors get to vote on the plan. That's not the case, but in Chapter 12, they can object to the proposed plan as filed by the debtor. And if the case, if confirmation is denied, debtor could amend the plan and try it again, or could dismiss out. It depends on the case. If it gets confirmed, then the debtor starts remitting money to Mark's office based on that plan that was confirmed by the court, and then he administers the case and pays creditors according to the plan. If, and more often than not, the plans run anywhere from 3 to 5 years. I would say probably more often 5 years, because there's not insignificant debt. But during the life of this plan, so to speak, that's being administered, if there's a huge change in circumstances, the code provides that the debtor could modify the plan as confirmed and propose a new plan. Things happen in between 3 and 5 years. Equipment goes bad or is malfunctioning, cattle die, et cetera, et cetera. So the code provides for a change. Upon completion of all payments to the trustee, he does a final report, and the clerk's office enters a discharge. And the discharge is the other bookend for the bankruptcy. The automatic stay is at the front end that protects any further collection efforts and allows debtor a breathing spell to reorganize debts. The discharge is an injunction, and it protects everything that the debtor did during that plan and discharges the debt. So with that said, let's talk, if we could talk a little bit more about pre-filing considerations. Mostly Peter and Pat would talk about how Debtors Council works with debtor and how Pat may or may not be stepping in even before the filing.
Yeah, if I could. So as an attorney, when I first speak to a farmer, there's a lot of information I need. I need to understand what is their farming operation, what do they do. I need to determine who their secured creditors are, who they are, what the security is. I need to look at the security documents to see what the terms are, who is responsible for it. I also need to determine who is the farm. What is the farm? Is it an individual owner? Is it a partnership? Is it a corporation? Is it an LLC? Fortunately, unlike Chapter 13, where only individuals can file, in a Chapter 12, any of those entities can file. So it can be a partnership, a LLC, yes.
Can it be a trust?
I think it can. I don't know that we've done that, but I think it can.
I think if anybody would have seen it, I have not seen that. Have you seen that?
No, but I don't see why not. Whereas a trust couldn't file a Chapter 13, but it could. It could be a nonprofit, I suppose, too. Sometimes it has to be more than one entity. There could be an LLC, let's say, that owns the property, a corporation that owns the cattle, a partnership or an individual that owns the equipment. There could be a lot of different, so sometimes...
Or just the land
land.
upon which crops are raised. So you have to understand who the debtor or debtors are.
Yes. And then sometimes you need to file a couple of different cases, and then you can consolidate them together, if that makes sense. You need to get an accurate and current valuation of their assets. How much is the land worth? How much is the cattle worth? How much is the equipment worth in its current shape? And there's been huge changes in valuation in the last couple of years in terms of cows are worth way less than they had been before. 1 year corn may be worth a lot, 1 year it may be worth nothing. It's hard, it varies. But at the time of filing, the value is what determines if we're going to cram down value, the debt to value.
How we're going to treat the claim in the
Right.
context of the bankruptcy.
You need to look at the last 3 years of tax returns. One of the issues of eligibility has to do with how much debt is there, what percentage of the income is farm income versus non-farm income. You want to look at the last 3 years of taxes. I think the lawyer should go to the farm and take a look at the farm to not only get a visual but understand the issues of the farm. What condition are the cows in if it's a dairy farm? What does the land look like? And I know Mark has Gary Conklin goes out to, is he here? Gary's here.
Who, by the way, is present in
Yes.
our audience today and has been working with Mark for many years, I believe the mid-90s.
And Gary will go out to the farm and do a report with photos and analysis and give it to the trustee and any interested parties, which is very helpful also. But that happens after it's filed. I think you as an attorney need to go out and take a look and get the lay of the land. I think that's real important. Before you file...
And why would you do that? Why would you want to see like the tractor or the milking equipment or the stall that the cows are in?
I can tell you a reason not to do it. My wife told me one day after I was at the farm and drove around the barn that I couldn't park my car in the garage until it changed its pungent. but no, you want to go to see, like I said, the condition, the number, how the farm is being operated, if they're collecting milk, how they're doing that. You want to take a look at it so you know when objections come in and they say something, you've been there, you have a better idea of not just what it looks like, but what the operation is like. You should, before you file, you should start at least preliminarily, if not totally, doing some projections. So if we can clear up the financial mess that you're in right now, how's it going to work? What are you going to do? And another big advantage of a 12 is that no payments are made to a trustee until the case is confirmed. And that case isn't confirmed usually for about 3 or so months.
And why does Peter raise that? In a Chapter 13, you have to commence making payments to the trustee 1 month after the filing.
Right. So in a 12, it gives the farmer an opportunity to build up some money, which they're going to need in many cases. Now, except if the creditor comes in, if the secured creditor comes in and says they want what's called adequate protection, and Pat will talk about that,
In detail.
You need to be able to provide for that and figure out what is adequate protection for this particular creditor with this particular collateral. Do you have what's called non-exempt property that you want to convert into exempt property? Now, what does that mean? So let's say a farmer has $10,000 in the bank and doesn't get an exemption for that $10,000. So that's in a Chapter 7, a trustee could take it. In a Chapter 12, a trustee could say, well, you've got to pay at least that much to your unsecured creditors. What if you took that $10,000 before you filed and converted it to something that was going to be exempt? So for instance, you could have a vehicle worth $4,500, let's say. You could buy a vehicle for $4,500, which is exempt, whereas the cash wouldn't be exempt. There's several other things you can do, but is there any non-exempt property you want to make into exempt property?
If we could just spend a little time on exemptions. I indicated that when the filing occurs, an estate is created, and that includes all of debtors' legal and equitable interests in whatever the debtor owns. And Congress has deemed it appropriate that certain of that property is protected from being liquidated or sold used to pay creditors, and those are called exemptions. And you can choose an exemption under the bankruptcy code, the federal exemptions, or you could choose New York exemptions. And part of the pre-filing consideration is to figure out which of those exemptions are better for the debtor and his or her situation. So it's still property of the estate, but it's protected from administration. And that's part of a debtor's fresh start. A debtor isn't supposed to fall on their face and be totally destitute. Congress has seen fit that there's certain assets that are protected. So depending on the value of the asset and what is owed, there might be a cushion there, and it may or may not be protected under either the federal or the state exemptions. It's an important tool and aspect of pre-bankruptcy planning.
Yes.
What types of, for a farmer, what types of assets are generally exempt? Is land, for example, exempt?
If it is their residence and it's an individual, if it's a partnership corporation, not so much. But if it's an individual and it's their residence, each individual who's filing gets $85,000 roughly of exemption on the equity in the real property. If it's not their residence, they don't. There is a wild card exemption in the federal exemptions that allows $12,000 or more, depending on some other issues.
But how much a debtor gets on a resident depends on the county and the area that they live with. It varies across the state, so you need to know what it would be in whatever county the debtor lives.
Right. Basically, that means Albany, I think, is more, but mostly the northern district in our courts, Utica and Syracuse, are all pretty much the same. Mm-hmm. But they are more closer to Albany and a lot more downstate. Another thing that is very often a good thing to do is to contact the secured creditors before filing bankruptcy. And if FSA is a creditor, I always contact FSA first to find out the details of this loan. I know Sue is no longer there. Is someone? You're the new Sue? Oh, wonderful. So. Right, so FSA will give you the information quicker than you can imagine they could possibly do it. I don't know how they do it, but they do. The information about the exact situation of the loan, exactly what's owed, how much the interest rate is, what the term is, if you did a Chapter 12, what the term would be that you could go for real property. And they will also, after the filing, come out and do an appraisal of the equipment, of the cows, and they do that fairly quickly. Usually they're happier when the debtor agrees with it and goes along with the appraisal. Sometimes they don't, but That's my job to get them to. But that's another thing you want to do beforehand. The other thing is you want to look around and see, should the toys go? What does the farmer have that they don't need? Do they need those ATVs? Maybe they do, but do they need those? Do they need that big fancy skid steer that they just bought and owe $40,000 on? Do they need all those things, or can they do with some other things? Do they also, would it be wise for them to consider changing the nature of their farm? Maybe reducing the herd, or maybe converting from dairy to beef, or maybe converting from, I had one farmer converting from onions to soy, because of the nature of the cost, the nature of the business, and so those are other things you want to look at.
But the timing of that is critical, because upon the filing, Mark's going to be taking a look at the financial of this particular debtor and whether, and this will segue perfectly into eligibility, is this debtor eligible for Chapter 12? And what does that mean, Mark?
Eligibility, I think, is one of the most interesting parts of Chapter 12. And let me just comment first about what Peter had said and something Judge Davis said, and I'll get right into eligibility. What I have seen as a former Chapter 7 trustee and a Chapter 13 trustee is that debtors do not file their bankruptcy until 1 day ahead of a foreclosure.
I can attest to that.
And then in a 7, if they're going to try to keep their property in a car, they'll probably end up then in a Chapter 13 after they get the discharge in the 7, and that's called a Chapter 20. In a Chapter 13, they file the day before the foreclosure because they have disposable income and they're going to pay the arrears through the plan and pay directly on their regular ongoing payment. They can do that in a 13. The problem in a Chapter 12 is that if they wait until the day before that foreclosure, their farming operation has declined and declined and declined. They're running out of money. They're not feeding the cows properly. They're not getting the supplements, so the milk production is down. By the time they file, if they wait that long, there's nothing to work with. And so it's frequently better for the Chapter 12 farmer to file where there's a really good operation going on. Gary Conklin can confirm that. Gary and I have talked about that for years, where the more you can generate an income in a 12, the better you're going to be, because you need the disposable income. So that's the one thing in comparing the cases. Second, Judge Davis mentioned these are 5-year plans. Once the 5-year plan's completed, I file this final report. However, in that plan, in order of confirmation, there can be modifications, say, of a mortgage, which stretches it out much longer than 5 years, and after the 5 years, those are direct payments. We have one case in Albany where the modification went out an additional 40 years. So these are modifications of the secured claims. Typically, every secured claim is breached. That's the American way, right? And you need to do that to free up money to feed the cows, to have the utilities going and things like that. Now,
To reorganize, which is the point of 12, is to
Yeah.
reorganize your debt.
Now let me go into eligibility, because a farm might look like a farm, it may smell like a farm, but it might not be a farm according to the bankruptcy code. A farm, to qualify, has to be producing something. And one of the best examples is a horse farm. Most horse farms, if anyone here has a horse, probably it's out at a farm, and the farmer is really a landlord. The farm may not be producing anything, but it's a landlord tenant. It's a boarding facility. If there is litigation over eligibility, this is going to be a hotly litigated issue because there's so much in favor of the debtor here that the major creditor is going to take a major haircut. And so they don't want that debtor in a Chapter 12. They want to kick it into a Chapter 11 or a Chapter even a 7 or a 13. And so horse farms are litigated. You can go back to 1986 and check every year, and you'll see how those are litigated. If that farm, though, has this boarding facility and they're also a crop farmer, then they might qualify. If it's an individual or a spouse, family, the farming debts have to be at least 50% of their claims, and their income has to be 50% coming from the farming operation. So in a lot of cases, a spouse might be a truck driver and have income, and they have to show that 50% of their income, though, is still coming from farming. Farmers love to set up entities, and I think they do this because they think that if they run into trouble, they're going to have an out. And as Peter had said, they may set up a corporation, maybe called Boulder Meadows, which owns the property. And then they'll have a farm which the debtor individually owns. They'll have the personal property, the tractors, things like that, in a partnership. And what Peter suggested, you may have to file 3 bankruptcies. The problem with the owner of that farm is a landlord to the individual. And so we have a landowner who is not a farmer, and that can be kicked out. So I find that a lot of farmers run into this problem by creating different entities. In their mind, they're doing the best thing until they get to bankruptcy, and then they've got a problem. Peter was the attorney in a case called Boulder Meadows, and that Judge Davis held that that was a landlord and did not qualify. So what you have is one entity filing a 13, one entity filing a 12, and the other entity probably in a Chapter 11. It can really get to be a mess.
If I could just point out one thing, in that case, for instance, so one of the entity was found not to be a farmer and could not be in a Chapter 12. Another entity was in a Chapter 12 and was allowed to be in a Chapter 12. And the end result is that, even though this was several years ago, the farm, it's still operating, it's still successfully operating, partly because of negotiations once the one was no longer in, and Pat's client actually was reasonable and we worked things out, and also because then another bankruptcy was filed up the road to allow it to continue. So sometimes bankruptcy is a tool where the end result doesn't have to be a successful discharge. As long as it's successful for the farmer, that's really the point of it. And bankruptcy is just a tool that helps you get from here to there.
But I think you also need to think about the nature of the farming. Farming has its inherent risks, and that could be weather, pests, diseases, fluctuating commodities. It's subject to risk as an operation, and that is an important aspect of eligibility, right, Mark?
Just a couple of quick ones, and then we'll move on. How about this one? The farmer doesn't own any land, leases the land, doesn't own any cows, leases the cows, doesn't own any tractors or other equipment, leases those. Is he a farmer? Yes, he's a farmer. He is self-employed. And even though he doesn't own anything, that's a farmer.
Because he's personally caring for the cows. Your case law will kind of parse these kind of things out for you. Got an entire packet. But he's caring for the cattle, and he's out there every day dealing with whatever the weather brings, et cetera, et cetera.
And the distinction of that would be the person that is operating a farm for the farmer. So the person managing this is dealing with the cows, dealing with the crops and all of that. He is not a farmer. He's getting a W-2. The farmer is the one that owns this and may be not actively involved, where the manager is, but one is the farmer, one is not the farmer. One other thing that is happening now as cities expand into more of an agricultural rural area is that farmers are trying to develop other avenues to generate income. One idea is called agritourism, where there may be setting up of hay rides, or I always thought putt-putt golf course. We have a rifle range in Chapter 12. Technically, that is not farming. The farmer still has to have a farming operation. So what they want to do is to file while they're farming, because a lot of these agritourism adventures are starting to generate more income than the farm. And there's in this transitional period where they may want to still be in a 12, but they may not qualify if they wait. Now, let me mention corporations, and then I'll end with that. An individual filing a Chapter 12 is different than a corporation or an LLC or a partnership, and I'll throw a trust in on that. I assume that may qualify, because there is no income requirement in a Chapter 12 corporation. A lot of people don't notice that. Take, for example, the horse farm. The horse farm's income is from breeding. It's not producing anything. But the corporation says, well, we're breeding horses, that qualifies for a horse farm. Just because there's income coming in from non-farming resources is not going to disqualify that farm. So there are some advantages in setting up a corporation. The problem is they're setting up different entities rather than having it all under one thing. Peter, it looks like you wanna.
I have a question. So if you have a horse farm that does not qualify for Chapter 12 because of the income issue, can you turn it into an LLC or a corporation and then file?
That's an excellent question, and I've been thinking about that for weeks, believe it or not, because there is a case in the materials where a corporation switched to an individual. The judge said that was okay, said it's the same farming operation. The IRS objected to that, and that ended up getting confirmed. But you're right. How about if the individual converted to the corporation and wiped out this income requirement? I have not seen a case on that point. I'd love to see it, to see what happens. I think the creditor would be objecting because there's transfers of property here, and once there's a transfer, isn't it due on the transfer, and there's going to be a problem.
The loans might be due on a
With that.
transfer of the interest, and that's happened before too.
But even if it's due on the transfer, can't you then reorganize it in the Chapter 12?
I think timing is everything.
Timing is everything.
I think timing is everything. I mean, the Albany case for Christopher's was an LLC, and that's in your materials, and it was found to be a farming operation. So you might, it's all, the devil's in the details. And that's why I commend the case law update to you. Just briefly, so we can move on, I just wanted to talk about getting retained as an attorney. You will have done all that financial investigation, pre-filing. You decide whether you want to take the case or not. You need to structure the arrangement, and you need to differentiate and be crystal clear about what basic services are, and there's a list of that in your materials, and what supplemental services are. In any event, you must execute the retainer agreement before you file the bankruptcy. And I refer you to sections of the code, they're 526 to 528. You have to have a fully executed retainer agreement under the code within 5 days of offering bankruptcy assistance to the debtor. And your contract has to be clear and conspicuous. As I indicate, talk about the services you provide, both basic and supplemental, and it should include the terms of the payment and also debtor's operational and legal obligation. And as Peter well knows, that means getting tax returns up to date if they're not, but getting that information to debtor's counsel and the trustee, so the debtor has, is vested in this contract as well. Farm budgets, cash flow projections, because all of that's going to be needed once the case is commenced, because you need to do monthly operating reports as a Chapter 12 debtor. So it's critical to collect all of that. Any fee paid in connection with the Chapter 12 is subject to court review. That's 329 of the code. And you have to file your agreement or your arrangement, financial arrangement, under Bankruptcy Rule 2016B. There's very strict requirements for disclosure about the amount and source of the fee. Is debtor paying it, or is dad, or whatever? And if there are any other attorneys involved, because fee sharing is prohibited under the code absent an association with the firm. And when the case is filed, if you are debtor's attorney, you want to do what is called a first day motion. You immediately out the gate want to, debtor has every right to hire you as attorney under the code again, but you have to bring that motion and file an affidavit of disinterested and verify that you don't hold an interest as debtor's counsel against either the state or the debtor, and bring it right away, because under Second Circuit law, any non-protunct approval is extremely rare. And that case is in your materials, the summary outline in your materials. It's in Ray Karen.
Judge, what is non-protunct?
Non-protunct, say you're running around, thank you, that's fair. You say you're running around trying to get the case going and this, that, and whatever, and it's like, oh my God, I didn't get myself approved, and it's 4, 5, 6 months later. Usually you're approved from the date the motion is filed. And it's got to, and to actually ask to be approved for prior to the filing and all the work you did there, and from the date of the filing there, that would, the non-protunct means looking back to the beginning of your assistance with the debtor. That's rare. It's very rare to get that approved. That's why I say consider it a first day motion. And Pat will get into some other important first day motions where you file, and you almost immediately file certain types of motions to get things on track correctly right out the gate. With that said, I note that we are already at 11 o'clock. We had intended a break. Do you want a break, or shall we keep going forward? Everybody feel free to get up as you need, and I'm hoping my None of you need to? Okay. So with that said,
Judge, may I ask a question? What you said about, you mentioned monthly operating reports, and as a lender, we're getting.
they can't hear you. They need you to get.
I don't have one. You mentioned monthly operating reports, and we're getting the gamut. Sometimes it's not, they're not, we gotta push the button.
It's almost like you have to.
Right up to.
Am I muffled?
Yeah.
Closer? Is that
Good,
better?
good.
Oh, I'm sorry. I don't do this very often. Monthly operating reports, I mean, we can get all kinds of stuff on paper. A piece of paper with scratching on it with manure, okay? They're incomplete, they're not very useful, that I find in many cases. Is any, do we agree? Yes, and it would be nice, is there any way of getting some kind of format for this, so it's useful to the creditors?
There is a format, but I would suggest that when you get something that isn't giving you what you need,
Okay.
call the attorney and tell them what you need. And I apologize for any of those that you've gotten from me.
Well, and if it isn't sufficient to make a determination, I can assure you, creditors counsel is going to object to something called the feasibility of the plan. But that gets a little bit ahead of ourselves. The devil is in the details.
If I see production, we're not getting production. I might see production that's going down. We haven't been out there. Why? You know, there's some things, those kind of things would be helpful to us. Even Gary Conklin would say the same thing.
Absolutely.
I know he's out there.
And that's why his report is filed on the docket of a given case. If Mark has retained him for a given case, and it sheds a lot of light. It talks about the historical aspects and the prospects.
The other thing I do is when I negotiate either an adequate protection order or a stipulation for plan treatment, I will put in that order the requirement that or cooperate with collateral inspections, so my client can go out there and inspect the collateral. And in addition, if the size of the herd is a concern, because there's been diminution of the herd, I'll put in there that they have to disclose on their operating reports a breakdown of how many animals they have and how many sales. No, I just make sure they add it to the operating report they already file. They have to add a section on there disclosing to me what the cow numbers are at that point.
Together that would be useful, or are we not allowed to present it?
Absolutely, and I think it's the debtor's attorney's responsibility to have a clear operating report that's filed timely every month.
Yeah.
Sure.
The other thing I've done is, as part of that longer term stipulation, is I'll have the debtor be required to complete a farm financial statement on a form provided by my client at least once a year. So then I'll send that out to their attorney and make them complete that. And if they don't complete it, that'll be an event of default, and we'll be back before the judge. Yep.
And he protects his client by including it in. And actually, this is a great segue now to the automatic stay and adequate protection. He'll include that in the orders. So, Pat?
Well, we didn't take a break, and I'm guessing the coffee's wearing off, so maybe a little humor? How about it? Now, with full disclosure, though, this might come as a surprise, but the universe of bankruptcy jokes is rather small. So I had a limited pool to choose from, but I'll give it a go. So Farmer Matthew is showing up each Sunday to services, and he's not looking good. And he looks bedraggled and depressed and just unkempt. And Father Murphy's really worried about him. So after Mass one day, Father Murphy says, "Matthew, you don't look good at all. What is the matter, my son?" And Matthew says, "Father, I don't know what to tell you. Milk prices are terrible. The wife's not happy with me. I'm struggling to pay my debts. I don't know what to do. I'm kind of at the end of my rope." So Father Murphy puts his hand on Matthew's shoulder and says, "Matthew, look to the good book. You'll find your answer there." Well, about a month goes by. Matthew pulls up to church, brand new car. Gets out, he looks like $1 million, dressed to the nines, big smile on his face, fantastic. Walks up and Father Murphy says, "Matthew, you look wonderful." He says, "Father, I gotta thank you. You were right. I looked to the good book and there was my answer. Matthew, chapter 12. So, see, thank you. That's but like I said, limited repertoire, right? So, all right. So, I just back up 30,000 feet, right? What is debt, right? What are we talking about? Debt is fundamentally an exchange of promises, right? So I have feed. I promise to give you feed. You promise to pay me for it. I am going to provide you with veterinary service, and you promise to pay me for it. I have money, and I agree to lend it to you, and you agree to pay me back with interest. And maybe to secure your repayment, you agree to pledge to me that, okay, if I don't repay, you can take something that I own. Could be my house, could be my tractor, could be my livestock. You can take that back from me, sell it, and use the proceeds from the sale to pay down the debt. So that's really what we're talking about here is two parties, a lender or a vendor, at some point in the past got together and agreed on some kind of an exchange. And now there's been a breach of those promises. The lender gave the money as was agreed, but the borrower has not repaid in accordance with the terms of the agreement. Now, normally, the terms of those mutual promises can be enforced by the creditor in the courts of your state, so New York State Court, which is, in general, pretty favorable to the creditor. You're allowed to go and sue and get a money judgment and garnish the person's wages or put a lien on their property. If you have a lien on their personal property, as long as you can do it without a breach of the peace, you can take it back without even having to go to court. You just go send the repo person out and take it back. So it's a very, very powerful rights of creditors under state law to enforce the terms of the promises that the debtor made. Well, what's bankruptcy law? Bankruptcy law is the federal government in the form of the federal bankruptcy court saying, notwithstanding what you agreed to between yourselves, and notwithstanding what your rights as a creditor might be to enforce the terms of that agreement in state court, we're going to come over on the top of you and supersede and change that arrangement. In general, to the detriment of the creditor, to allow the debtor an opportunity to have a fresh start and reorganize. Now, it's not an unlimited right. There are rights that creditors have to object to and contextualize that rearrangement. But fundamentally, it is the debtor using the power of the federal court to rearrange and redefine the terms of the promises they made when you first had your debt exchange.
So-called supremacy clause.
Right. And so when a client is calling me as a creditor with a debtor who's either what I'm going to call in the zone of bankruptcy, right? We're circling the drain. We're not. People call me. I say I deal in broken things, right? Broken contracts, broken promises. People are calling me saying, I lent someone money or provided them with a product or a service, and they're not paying as they agreed. So the first and most important question I'm going to want to find out is, what kind of a creditor are you? And we've touched on this throughout the conversation. Are you a secured creditor? So you're a creditor where, in exchange for the promise to repay, as part of the promise to repay, the debtor has agreed that you can take back property that they own and sell it. Or are you an unsecured creditor? In other words, the debtor has agreed, promised to repay you, but they haven't pledged any property that they have as collateral for your debt.
And the easiest examples of a secured creditor, your home secures the loan that you got to take out a mortgage. Your car secures the loan that you took out to buy your car. Those are secured creditors. Whereas an unsecured creditor is somebody who's just selling the feed and then hopefully gets paid within 30 days receipt of the same. There's nothing securing that.
Yeah, so really when you think about it, if you're an unsecured creditor, there's only been one promise to repay. So there's a note or an invoice or a contract, and the debtor promised to repay it. That's the only agreement. If you're a secured creditor, there are two promises to pay, right? There's the debtor saying, I'm signing a note, but also here's a second agreement. Could be a mortgage pledging a real property, or it could be a security agreement pledging personal property, livestock or farm equipment. So if you think about the note and mortgage or note and security agreement, the note is their individual promise to pay. The mortgage is the farm's promise to pay or the livestock's promise to pay, because you as the creditor can look to that property to take it, sell it, and apply it to pay down the obligation. So that's the first question I'm going to be asking is what kind of creditor you are. If you are a secured creditor, I'm going to be looking to find out, okay, what is your collateral? Do you know what your collateral is? Do you know where it is? Do you know how much it's worth? And also, have you perfected your lien in that collateral? So if you think about it, you and I have an agreement, you pledge your car to me as collateral for repayment. Okay, but that's an agreement between us. What's to prevent you from tomorrow going out and promising the same car as collateral to Peter to borrow money from him? Well, what we've done is create a system of sort of registering secured agreements, so that if I'm a creditor, I can go and look and make sure that you haven't already pledged this farm, your livestock, your tractor to another creditor. And that's via a filing system, either recording your mortgage if it's real property with the county clerk, or recording a UCC financing statement with the Department of State. So I, as a creditor then, if I want to make sure that I'm perfected, I want to make sure that I've taken the right steps to file either with the county clerk or with the Department of State to perfect my security interest. Because then what's going to happen is if I go into bankruptcy, if I haven't perfected my security interest, the bankruptcy trustee or the debtor as part of the case might be able to void my lien. So I want to make sure that I know where my collateral is, what it is, how much it's worth, and have I perfected my security interest.
And hopefully you're the first one to perfect on property, because we all know some farmers take out a second mortgage, a third mortgage to operate the farm. So hopefully Pat's the first mortgage.
So now let's say you're calling me and you've received a bankruptcy notice. The debtor has filed Chapter 12. The first and most important thing I'm going to tell you is stop. Turn off statements, discontinue any collection activity you may be engaging in, don't make any phone calls. And I say to my clients, have no further contact with the debtor. If the debtor contacts you and wants to make arrangements or discuss the matter, I would suggest having them talk to their attorney who can, I'd say it's in litigation, you have an attorney, we have an attorney, our attorney should just talk. Because I say to people,
So Pat should be talking to Peter and vice versa, not the debtor and the creditor.
I always say for the non-bankruptcy practitioner, either as a lawyer or as a creditor, if you don't know anything about bankruptcy, just know about the automatic stay. That's the most important thing, because that's the one situation, under normal circumstances, the worst thing that's going to happen to you is you're not going to get paid what you're owed. But if you violate the automatic stay, in other words, you continue to try to collect against the debtor, demand payment, repossess your collateral after they've filed bankruptcy, now it gets worse. Now not only are you possibly not going to get paid what you're owed, you may have to pay out money to the debtor as a sanction for having violated the bankruptcy stay. So that's the most important thing, is you want to be stopping any collection activity. And also, if you have engaged any third parties to engage in collection activity on your behalf, you want to make sure that you've contacted them in writing and confirm that they're going to stop their collection activity. So you've sent it to a collection agency, you've sent it to an attorney, you've sent it to the sheriff, whoever you might have referred it to. You want to make sure that you get that back from them and tell them that they also need to be aware of the bankruptcy and stop acting as your agent in an effort to collect against the debtor, because that's going to be a violation of the stay as against you. So now they're in bankruptcy. If you're an unsecured creditor in bankruptcy, so you were a feed supplier, you've supplied the debtor feed over a period of time, and they just never paid the bill or didn't pay the full amount, or you provided veterinary services, I'm going to tell you at that point, unless there's fraud, so unless there's a reason to think that the debtor bought feed from you without ever having the intention of repaying, so they knew that they were going to file bankruptcy and they just took the feed anyway, unless there's fraud, there's not much to do as an unsecured creditor except sit back, file your proof of claim in the bankruptcy case so that your claim is of record, and kind of wait and see what happens.
Which, by the way, has to be done within 70 days of the filing.
Right. So for the most part, you're sitting back, and that's why that's an important function that Mark Swimler plays as the Chapter 12 trustee. He is, one of his jobs is to look out for the interests of the unsecured creditor body. Because chances are, if you're a relatively small unsecured creditor, a few $1,000s, it's not economical for you to hire me to do all the due diligence about, well, I don't know, is this debtor eligible to be a Chapter 12 debtor? Have they committed all of their, the income they need to the plan to satisfy what's called the best interest of creditors test? Have they listed all their creditors? It probably is not economically feasible for you to hire an attorney to do that and do that due diligence as an unsecured creditor. So that's one of Mark's job, is to kind of look out and safeguard the interest of the creditor body as a whole and make sure that the debtor is in fact eligible, that they've proposed a feasible plan, that they're paying to all of their creditors at least what those creditors would have gotten if this was a Chapter 7 liquidation.
So we always look at liquidation to see what a Chapter 7 trustee would get. If there's an amount there, they have to at least pay that into a Chapter 12.
There are standards that the code sets up under 1222 and 1225, and the first section is mandatory A under each of those sections, and the section B are what the plan may do. And part of confirmation, Mark's looking at the entire picture and deciding, and so is Pat, they're looking at the entire picture to see if they're going to lodge an objection to the plan as it's been proposed. And that's what confirmation hearings are all about. But before we move on to confirmation, can you talk a little bit about adequate protection, please?
Sure. So we're talking about secured creditors. One of the rights, that most fundamental rights, is a secured creditor has. The notion is that you may end up not making as much profit as you would hope to, as an interest income. And you may end up getting repaid over a longer period of time than you originally hoped. So you're harmed because the debtor gets to repay you at a lower interest rate and over a long period of time. But other than that, the fact that the debtor filed a Chapter 12 bankruptcy is not supposed to harm you or make you worse off than you were when the case was filed. Because both in the period of time before the plan is confirmed and once the plan is confirmed, you're entitled to what they call adequate protection, okay? So the bankruptcy case is filed. Let's say the debtor makes no payments, okay? While the case is going on and we're considering whether it can be confirmed and what the repayment terms should be. Well, what's happening when they're not making payments? Well, the interest is running on your debt at whatever rate that you're entitled to interest. That rate can be subject to negotiation or litigation, but for sure you're entitled to interest. So your interest is accumulating, and depending on the nature of your collateral is depreciating in value. So let's take an example. I lend you money, you buy a tractor, I take back a lien on the tractor, okay? You file the bankruptcy and you stop making payments. Well, now you're using the tractor, so the tractor's depreciating in value, and I'm not getting payments, so my interest is accruing. Well, that's a harm to me, right? Because my debt is increasing and the value of the collateral securing that debt is decreasing. Well, now the debtor has to make payments to make sure that I'm adequately protected during the pendency of the case. So whatever that delta is between the interest accrual and the depreciation of the collateral, the debtor's got to make at least that much in payments to make sure that I stay at least at baseline while the case is going on. Now, as a practical matter, most of the time, we don't even get into an argument about that, because most of the time what the debtor's going to want to do is actually start paying down the debt, actually start making payments that are going to service the long-term debt, because they stopped paying all their unsecured creditors. They get a reset on that. So they're just paying their trade debt and then whatever they pay you for adequate protection. So most of the time, we'll sort of use it as a trial period on, okay, look, we think this debt probably is going to get termed out over 20 years at an interest rate of 6%. So why don't you go ahead and figure out what that monthly payment would be and start making those payments as adequate protection payments. Because then not only are you providing the creditor with adequate protection, which you have to do, but you're actually getting a jump start on paying down the debt at a time when your financial circumstances are pretty favorable.
But we've already told the audience that basically the debtor doesn't make any payments to Mark's office until the case is confirmed. So how does a creditor go about, a secured creditor, go about getting adequate protection payments on his or her collateral? You
either negotiate a stipulation with the debtor through their attorney, or you bring a motion onto the court saying, I want adequate protection.
If I could just say, it's
And it only goes until confirmation. Then the creditor will be treated according to the terms of the confirmed plan. Yes.
So a few years ago, there was a Geico ad with a farmer, and it was a spelling bee, and they said, okay, spell the word cow. And he went, cow, C-O-W-E-I-E-I-O. Buzz, and he lost. My point is, the creditor attorney has their hand on the buzzer and is ready to push that buzzer at the earliest possible minute. So that's an important factor. You got to remember that you got to have things right.
One thing I would add to this discussion here is the motion for cash collateral, which would resolve the adequate protection. You have let's say a dairy farmer with a lien on cows or anything that's produced. The cow produces milk, the milk is sold, that cash is liened by Farm Service or NBT. The debtor, in turn, is spending that cash improperly. So the way to avoid all of this is for the farmer to have a motion to use cash collateral, and the end result is adequate protection, and that all gets worked out. But it's safer to have a motion for cash collateral rather than a motion for adequate protection.
Which Peter would bring. Peter would file the motion for cash collateral on behalf of his client, again, as a first day motion. I mean, it never really happens on the first day, but as soon and as close to the filing date as possible, saying, we request use of these proceeds to do that. And Pat would jump in and object and say, well, I need to be adequately protected first before you get to use the balance of the cash that's available.
Yeah, so the gist of it is, the debtor in Chapter 12 has all kinds of property that's been pledged as collateral for his or her obligations. They're allowed to use that collateral, continue using that collateral in the ordinary course of business without the permission of their creditor, without the permission of the court, except for cash collateral. So if I, as a farmer, have pledged my milk account or bank account as collateral to a creditor, I'm not allowed to use that cash unless, to operate my business, unless either the creditor has agreed that I may use it or the judge has granted me the right to use, permission to use the cash collateral.
Is that also true for corn crops that are already harvested
So that would,
with a lien on them?
the cash from that, if they were going to use the cash from that, they would, if they were going to sell it in the ordinary course of business, they could do that, but they would, if they wanted to use the cash to, reinvest it in an operation business, then it would become, at that point, it becomes cash collateral. And
If they have a lien on the corn, and
Right.
the corn is used just on the farm with the animals on the farm, does that cash collateral come into that?
that's not being sold then, that's just being used.
So they
As
can
long as it's an
continue to
ordinary
use it.
course of business. Right.
Could you maybe expand on, quote unquote, the ordinary course of business? Because the code provides for both that and non-ordinary course of
Right.
business, and
So-
what the debtor can and cannot do.
Yeah, easiest example would be you have a dairy farm, a certain amount of culling of cows is going to happen in the ordinary course of business. You have an unproductive animal and you put it out for beef. That's generally considered in the ordinary course of business. You're not going to need permission of creditor or the court to cull cows, but you're looking to sell off young stock to improve your cash flow. That's not in the ordinary course of business, although it's a very ordinary thing for farmers, unfortunately, in distress to do, is sell off the future of the farm by selling off young stock. That's going to be considered outside the ordinary course of business, either going to require consent of the creditor or permission from the bankruptcy court to do
And
that.
Pat would be in court right away.
I would not, we won't be happy. Yeah, so selling off selling off collateral and not paying the real estate taxes are things that get my clients worked up. Yes.
So in that case, let's say, that scenario that the heifers get sold, you go to court, what happens to the farm?
Yeah, I'm going to say at that.
What's the teeth to that to prevent that from happening?
Yeah, so I'm going to say at that point that you may be liable to have the confirmation of the plan denied for lack of good faith, because you're selling off my collateral and damaging me, especially to the extent you were proposing not to pay me in full, because, so one of the big powers of reorganizing in a Chapter 12 is, if I have collateral that's worth less than what you owe me, you can get out of that debt by just paying me the value of the collateral. So let's say I'm owed $200,000, okay, but my collateral is only worth $100,000. In the Chapter 12, you can satisfy the debt by just paying the $100,000 as the value of my collateral and treating that $100,000 deficiency as an unsecured claim and pay me pennies on the dollar.
Which is one of three ways of treating a secured creditor and proposing the plan, and that would be part of confirmation. Debtor's plan proposes to do that, for example, and fortunately, Peter's client got an appraisal, and there may or may not be a contested confirmation hearing. Peter will say, no, it's not worth that much, it's worth less. And then the parties hopefully work it out, and I don't have to do a valuation hearing.
Right. So I lend secured by a 200-cow dairy farm. You go into bankruptcy and look to cram me down because there's only 100 animals. I'm going to be wondering what happened to my other 100 cows. And if that was because you sold them off outside the ordinary course of business, I'm going to object. And one of the requirements of plan confirmation is the plan be proposed in good faith. So what I'm going to say there is that's not a good faith, not proposing a plan in good faith, because you're trying to take advantage of the fact that you converted my collateral. Then, if it ultimately ends up and you convert to a Chapter 7 and try to get discharged from the debt, I'm going to be talking to my client about bringing an action to declare the value of my missing collateral not discharged. Because conversion of collateral, I'm going to make the argument, you should not be allowed to discharge debt that you have accrued because you converted my collateral.
I hate to ask this question, I shouldn't ask this question, but couldn't you do that in a Chapter 12?
Bring a non-dischargeability proceeding?
Absolutely.
Yeah, sure.
Absolutely.
Now
And
forget I said it.
Yeah, no, well, I could, but I would think, you know.
He did suggest it.
Yeah, I mean, if I'm a creditor in that situation, I'm gonna prefer to try to take down the 12 by making the motion to dismiss for lack of good faith, as opposed to having it deemed non-dischargeable. Because even if I'm successful in having it deemed non-dischargeable in the Chapter 12, my clients get to sit and wait for 5 years until the plan's completed to be able to collect the debt.
And we talked about the discharge. That's the other end. I mean, that's a strong it's an injunction at the end of the case, and you can bring actions to accept from the discharge a particular debt, or if the debtor was so egregious in his or her behavior, you could also bring an action to disallow the discharge in its entirety, which is like the most severe sanction in bankruptcy and rarely seen. Usually a creditor protects his or her own claim and debt.
Well, and to that point too, that's where I find, you know, my clients, the extent to which they get hurt in a Chapter 12 is often a function of how much firsthand information they've gotten either before and after the Chapter 12 is filed. So if you say to me, I'm a secured creditor, this debtor just filed Chapter 12, and I haven't been on the farm in 3 years, you could be in trouble because you don't have an up-to-date inventory. It's going to be very hard to argue if the debtor says, well, I didn't just sell these animals off. I had a mastitis outbreak and I lost a bunch of cows to illness. Well, you know, and it was over the course of the last 3 years. I'm going to have a hard time disproving that unless I've been either myself or an agent going out to the farm every few months, checking on my collateral and getting an itemized list of all of, you know, what are the cow numbers and what's my equipment list, and having the debtor sign off on that list saying, yes, I still have this item, your collateral's still here, here's where it is, here's the condition that it's in. So creditors who keep an eye on their collateral and maintain that ongoing relationship with the farmer are going to usually end up in a better position. And that ends up being the case during the course of the bankruptcy as well. I mentioned before, it's one of the things I will almost always negotiate as part of a consensual workout is the debtor has to agree to cooperate with inspections upon reasonable notice. I'll sometimes put in triggers with, it's a default if the herd drops below a certain size. That's an automatic event of default, and we're back before the judge saying, hey, judge, look we've had a collateral drop here of 1/3 over the last 3 months. Something is wrong here. The animals are
And
not.
how would Pat come before me? He would bring a motion seeking relief from the automatic stay. In other words, my collateral is depreciating rapidly. I only have 5 cows left instead of 50 cows. He would lay all that out in the motion, say, Judge, please lift the stay, the automatic stay, so I can at least proceed against the balance of the collateral securing my claim. And then they would go to auction or however he deemed it appropriate. But with that said, can we just segue a little bit into confirmation now and the issues involved on wearing first the proposal of the plan on behalf of the debtor, and then how or to what extent would both the trustee, who is protecting the unsecured creditors, plus just the integrity of the system, and Pat, when he would come in and object. Besides eligibility, confirmation is the other time frame where you see more activity from the creditors objecting, protecting their interests and rights. So if debtor got through the eligibility gate, now he or she needs to get the case confirmed to move on. Peter, what are the things that you can do for your client as provided for under 1222 and 1225?
Okay, so the plan itself must be submitted within 90 days of filing of the bankruptcy, unless there's a good reason to extend it, but generally it should be done within the 90 days. And it must do certain things. It must provide for payments of fixed amounts to the trustee on a regular basis. Now, in a Chapter 13, monthly payments have to be made. In a Chapter 12, it doesn't have to be monthly. It could be annually, based on if there's a harvest at the end of the growing season. That's when the money comes in. That's when a payment can get made. So, or if it's every quarter when they sell off some beef cows or something. So it can be done in a regular way, but not necessarily monthly way, for fixed amounts. All disposable income has to be paid to the trustee over a 3 to 5 year period.
What does that mean?
Okay, so what comes in, what goes out, what's left over. Is that good enough? So what's left over is disposable income. That's really simplified.
Income minus expenses necessary for, operation of the farm and family needs if it's an individual. And then there's something at the end, and that's revealed on the schedules. Yes?
At the 341, let's say Peter's the attorney.
What's the 341?
341.
Meeting
What's
of
the
creditors.
341?
The meeting of creditors that occurs.
It's a meeting of creditors. The attorney, about 7 days before, would provide tax returns for the last 2 or 3 years. You're going to find that they lost money for those 2 or 3 years. And so what Peter's going to do is start filing monthly operating reports. And what this plan has to do is to modify probably all of the secured claims so it creates feasibility. It creates a break even, at least in starting out. So we're looking at monthly operating reports during the confirmation process to at least say they're breaking even. They're going to be able to stay in business. Then we're looking at projections over the 5 years to see what is their long-term plan. And there's agencies out there to help prepare those. FarmNet, it's out of Cornell University and places like that. And we're looking to see, can they bounce back into a profitable kind of business? So the monthly operating reports and the projections are very important to have. And we're looking at this interrelationship between the secured creditors, that treatment, and liquidation feasibility, and trying to put this all together as far as the trustee is concerned. Pat is probably just looking at his client to see what the treatment is and whether that's a commercially reasonable treatment based on the Howe decision of Judge Davis.
Yeah, so if I'm a secured creditor, and we'll talk about kind of the things, I'm looking mostly at the repayment of my debt. What are you doing with my debt? That gets to the point I was saying before. If you're an unsecured creditor, in theory, you're really interested in, is the debtor actually committing all their disposable income? Or are they hiding income? Are they paying the value of their non-exempt assets into the plan? Because that's the money that the trustee is going to use to distribute to unsecured creditors.
Let's slow down a little bit. Paying the non-exempt value of their assets. Mark said liquidation. Pat said non-exempt value of their assets. Can we parse that so that folks can understand what that means? You know there's property of the estate. The code, or either the code or the New York exemptions, let debtor keep a certain minimal amount of the value of their assets. It's protected and part of their fresh start. But by way of an example, say the real property is worth $400,000, and the farmer was doing really well until mastitis hit, and he had paid down and really only owed $150,000 left on his mortgage. Well, all of a sudden he's got that cushion, that $250,000 cushion. Some of that he gets to claim as exempt pursuant to either the code or New York exemptions. The rest is considered non-exempt value. And whatever the balance is, unsecured creditors have to get that. They have to be paid at least that. That's the liquidation value. That's the Chapter 7 test. If the debtor filed a Chapter 7, the trustee would sell it and get that money out to creditors after, of course, Pat's $150,000 are paid. No.
From the operations of the farm. From the operations of the farm. So the theory is that, so you've got the value of the property, okay, deduct any liens that secured creditors hold, and then that leaves you with your equity, right? And then you're allowed certain exemptions. You're allowed to take portions of that equity and protect it from your creditors. So if there's anything left over, value minus liens minus equity, exempt equity leaves you non-exempt equity. That's the amount of money. You have to pay at least that amount of money through over the life of your plan to the trustee, and that's what gets paid out to unsecured creditors.
And it's a requirement of confirmation.
So is that a benchmark, or is that a requirement that you have to liquidate enough of the value in order to generate that?
You don't have to liquidate.
Okay.
You just have to pay enough to cover what would have been liquidated if it were a Chapter 7.
Great question.
And if you don't have credit history, enough credit history, how do you generate that income? It has to be through the farm income.
Correct.
Mm-hmm.
Correct.
Could be a
so
sale
that
of a part of the farm.
Then you might have to sell part of the farm, yeah.
you might have. So those are requirements of the plan. Another requirement is that you pay at least the present value of collateral that secures all debts, and that's the cram down we're talking about. At least that much has to be paid in. And there are certain things you can do in a plan. If it's an individual and there's domestic support obligation, you can, usually you have to pay it in full in the plan unless you're putting all of your disposable income into the plan for 5 years. Then you may pay less than that in the plan. Although it doesn't go away, it's still. You also may pay secured creditors in longer than 5 years, and you may pay them at a lower interest based on the till rate.
What is the till rate? We're throwing another term of art out. It's a United States Supreme Court decision. Pat?
So if I'm a secured creditor, there are three things that I'm looking at to object on. One is the debtor trying to pay me less than what I'm owed? Not in terms of interest, but are they trying to reduce the principal amount of what I'm owed?
To the value.
Which they can do if I'm undersecured. In other words, if the value of my collateral is less than what I'm owed, they can get out of the bankruptcy by paying me only the value of my collateral. That was the example I gave before. I'm owed 200,000, but my collateral is only worth 100 grand. They can get out of this by paying me 100 grand. But that presupposes that we have an agreement about what the value of my collateral is, which we often will disagree about. So Peter comes in and proposes a plan that says Pat's client is secured by the livestock and farm equipment. I have an appraisal that says the value of the livestock and farm equipment as of the date of the bankruptcy filing was $100,000. I am certainly entitled to get my own appraisal and bring an appraiser in who says, actually, no, you've undervalued that equipment, you've undervalued the cows, the value is actually $150,000. And then we either negotiate that, or if we can't, we have a valuation hearing where we put our appraisers on to testify. There's a battle of the appraisers, and then Judge Davis would decide, who's right, who's wrong, or somewhere in the middle, and then would set the value of my collateral. So if I'm undersecured, there may be an objection and a fight or negotiation about what the value of my claim is based on what the value of my collateral is. The other is, what are the repayment terms? So if you actually look at Chapter 12 of the Bankruptcy Code, it just says that the debtor has the right to modify the claim of the creditor. It doesn't say anything about, like, okay, well, does that mean they could say, great, I'm going to repay you over 99 years with 1% interest? There's actually nothing in the Bankruptcy Code itself, in the language of the statute, that says you can't do that. But what the courts have said is they have presumed there to be a requirement of commercial reasonableness. So in other words, no reasonable lender would lend someone money on a 99-year term with 1% interest, right? That's not commercially reasonable. So you'd be looking at what would a reasonable lender, what terms would a reasonable lender give to a debtor with a similar asset picture. So I have a debtor who has real property worth $200,000 and they owe $150,000 to the creditor. What would the repayment term, a reasonable repayment term, be for a lender, both in terms of the repayment term and the interest rate? And that would be the argument you'd have. I think with a little bit of a thumb on the scale in favor of the debtor, recognizing that it's a Chapter 12, the whole idea is to allow the debtor to reorganize. Because the practical reality is, for many of these debtors, no lender would lend them money under any circumstances because they're bankrupt, right? So, but the theory is, controlling for the fact that they're not bankrupt, in general, what sort of loan could you get if you were trying to buy a $200,000 farm, you had $50,000 to put down, you needed to finance $150,000. What is the repayment term that most reasonable creditors would grant you in terms of repayment term and rate? And that would be sort of the baseline for the negotiation and necessary litigation about whether the repayment term in the Chapter 12 was commercially reasonable.
And of course, that repayment term, that reasonable repayment term, would be entirely different for the cows.
Right.
Right? Because they don't last 30 or 40 years.
Right.
And so the commercial reasonableness of valuing the cows, should another creditor separately be lien or have a lien on them, that would be entirely different than a mortgage.
And then the last element that you're looking at as a creditor as a possible objection is feasibility. So one of the things the debtor has to prove in order to get their plan confirmed is they can make the payments. And what the courts say, that has to be based on some objective reality. It can't just be hopes and dreams. You have to be able to put together a budget with financial projections that show that there's some likelihood that you can make these payments. Again, I'm going to say, I think the case law is fair to say, a little bit of a thumb on the scale again in favor of the debtor, that, look, there has to be some objective evidence, but we understand that it's very difficult to predict these things with certainty. Who knows what the price of milk's going to be 5 months from now, let alone 5 years from now. So we're going to look at it with maybe a more generous eye from the court standpoint, but nevertheless, there has to be some reasonable basis rooted in numbers to make you think the debtor can reorganize.
The case law basically says it has to be a reasonable probability, not a possibility. And debtor doesn't have to guarantee And that's a combination of all the case law. So a probability is stronger than possibility, but not quite the quote-unquote guaranteed success.
And the other thing to think about too in that regard is, if you think about it, the Chapter 12 is not going to actually make the farmer any more money, right? Their income is the same, right? It's not going to increase milk production. It's not going to increase the price of milk. Their income is going to remain the same. The Chapter 12 filing's not going to change their operational trade debt, right? It's not going to make their feed cheaper. It's not going to make the vet bill go down, right? All of that is going to be, so their income and ordinary expenses are not impacted by the Chapter 12. What does the Chapter 12 do? It does two things. It resets them on their unsecured debt. So they have this huge pile of accrued trade debt, unsecured debt. They get a reset on that. That gets put into the Chapter 12. The creditors are going to get paid pennies on the dollar, and they're going to get wiped out. So it allows them to dig themselves out of a trade debt hole they would probably never be able to get out of. And it allows them to reduce the debt service on their long-term debt, right? Because they're extending the term out, they're reducing the interest rate, so there should be lowering the payment on their
And the monthly
long-term debt service.
payment on
Right.
on that.
So that's, if you think about it, that's what's, so we're, income's the same, at least not changing as a result of the 12. Operating expenses are the same. What's going down is payments on old, bad, unsecured debt and your payments on your long-term secured debt. That's going down. And you're hoping that this additional amount of money here is enough to improve the cash flow of the farm and make the reorganization feasible. What I'll say though is, for the most part, I will tell my clients that it doesn't make sense to litigate feasibility. Because I say it's the one thing that will prove itself, right? You could pay me all kinds of legal fees to have a big hearing before the judge to determine whether the debtor's reorganization is feasible, or as long as we can agree on the valuation and as long as we can agree on the repayment terms, let the plan be confirmed, and feasibility will prove itself, because either the debtor will make the payments or they won't, right? So it's the one thing that will actually prove itself. So feasibility is actually one of the less frequently litigated issues in confirmation, just because the economics of it. As long as the debtor is proposing something that might theoretically work and they have the ability to make some kind of an adequate protection payment or appropriate payment to my client in the meantime, most of the time you're better off having an agreed plan, letting it get confirmed, and then, like I said, feasibility ends up proving itself one way or the other.
It's,
So what happens if the farm in this scenario fails to make the payment to the trustee?
Right. So I'm going to have, if it's my client, I have a stipulation that establishes the treatment of my claim and has a provision in there that says, if you default in making a payment to the Chapter 12 trustee, okay, I'm going to send you a notice saying you've defaulted in your payment. If you don't cure that default within 21 days, then I'm going to be able to submit an order to the court lifting the automatic stay and allowing me to commence or continue foreclosure, allowing me to bring an action to repossess the livestock and farm equipment. And then likewise, it's if you default in payments to the trustee, if you don't pay your property taxes on time, if you don't maintain insurance with my client named as a lost payee. So any of those events of default, I'm going to give you notice and give your attorney notice and an opportunity to cure it. And if you don't, I'm going to be before the judge asking for relief from the stay. Or in the more likely scenario, the farmer's attorney is going to be running into court, bringing a motion saying, look, we had a change in circumstances, we need to modify the terms of the plan, we need, a couple months off, we had
a breathing spell to get back on our
right,
feet,
we had
to
some
get
kind
over
of a
whatever.
mechanical breakdown or financial hiccup, but we're otherwise going to be okay, and then so there's a little back and forth there about whether we do it tomorrow.
And with that scenario, frequently I would be moving to dismiss also if the payments aren't coming in. I think we had a question over here.
Now, how frequently can a farmer, how frequently can a farmer declare Chapter 12? Is there a waiting period?
No, there's not. Unlike Chapter 13, where there's certain requirements you have to prove to file another one, if you were in a case and that case has been closed, not just dismissed, but closed, which is usually another month or so after dismissal, if they're no longer in a bankruptcy, they can file again. there's
You
no
can't
limit.
have a case not closed and filed because of the estate, the bankruptcy estate. It's too confusing to creditors. Well, what case do I do something in? So it has to be closed before another bankruptcy can be filed.
But that's another circumstance in which I mentioned before, I would be looking to object on the grounds or make a motion to dismiss on the grounds of lack of good faith because there was a conversion of collateral. If there were serial bankruptcy filings, I might be looking to bring a motion to dismiss based on lack of good faith, right? So I get relief from the, oh, sorry.
The gentleman in the back?
Sure.
So this is like kind of a two-part question, look back, look forward, and might be extraordinary in its action, but a conservation easement, purchase or development right. So let's go to the $400,000 value property. The mortgage is down to $150,000. Farmer is in an area where development's getting closer. And through the state and not-for-profit, here, farmer, we'll give you $250,000. You now ease away your rights to develop this property in the form of a deed, and we'll give you the money. So if that happens, let's say a year before the farmer then files for bankruptcy, is there any look back? Or if it happens a year after you have the plan in place, does that money then have to be used to pay the creditors of any type?
Sales. Talk about it.
Yeah, so going forward, once you file the bankruptcy, if you're going to sell anything, the rights or property or anything, out of the ordinary course, you need to make a motion to the court on notice to all of the creditors seeking approval of that, and also discussing where that money is going to go. So if you want to combine, you want to pay some towards the secured credit. For instance, if there's a mortgage on the property, the mortgage holder might want that money. He might say, well, you're selling something that I've got a security interest in, so you need to pay us. And you pay us off, we're fine with it. Or the farmer may say, I want to buy 100 more cows with this money. Or the trustee may say, I want all the money to go to the trustee so that he can then distribute it out to creditors. So that all would get approved by the court. Going backwards,
Might not be eligible.
I think as long as it wasn't fraudulent.
Right.
The transaction you described doesn't sound to me to be fraudulent. It sounds like a quid pro quo exchange for fair market value. That wouldn't be subject to avoidance. But if I'll change the hypothetical to, I was thinking things were going sour, I might end up going bankrupt. So I sold half the farm to cousin Mo for $1 with the agreement that once I got my feet back, Mo was going to sell it back to me. That would be considered a conveyance and a fraud, and could be the trustee could look to avoid that transaction, bring the property back from cousin Mo into the bankrupt estate, and then force you to pay the non-exempt portion of that value to your creditors.
what might be a question, is what did he do with that money? That's the question. Trace that money. Where did that money, the farmer, do with that money up to the time of filing?
So what's on your horizon, just for a heads up? I know the farm, I'm in Albany County, years ago, got one of the first easements, $850,000. And it's still a family operation, it goes to the next generation. But ask the farmer who took the $850, what are you doing with it? And that's my retirement. So off the farm it goes. Now the value of the property for best use is knocked down. Next generation has no working capital. So go for the line of credit and so forth. Now everything's compressed and you can't sell it for anything but a farm or the gentleman's estate type of thing. So, how do you manage that? How do you predict that? I don't know. But how do you, on a plan going forward, you kind of, the farmer's in a squeeze.
That's one of the things I really appreciate about the work that FarmNet does. And I know some of my clients have a sort of a financial services or tax advisement piece that they can really provide that valuable advice to farmers. Because I often think, Chapter 11 most of the time when you're dealing with even a small to medium-sized business, that business has a bookkeeper or an accountant, maybe an attorney, kind of a business attorney, to give them advice about how to, what prudent investments are and how to maintain their books in a way that makes sense. And then on the other side, Chapter 7 or 13, when it's a consumer, most people, their finances are relatively straightforward. It's, figure out what's going on with their checkbook or QuickBooks. But the farmer is often running a very complicated business, generating lots and lots of income, and they don't have anyone advising them about what the consequences can be of entering into financial transactions, or just literally keeping track of what's coming in and what's going out, and how the operations are working. So I imagine that is going to be a challenge for Peter to say, look, we need to put together a budget and projections, and this farmer has been operating $1 million business out of their personal checkbook for as long as they can remember, or in cash or handwritten receipts or whatever, and it can be hard to put together all of that in a way that is necessary to determine, is a reorganization viable, and what would that look like?
But that's exactly part of the pre-filing considerations that Peter talked about. He's going to make sure that there weren't any transfers within 90 days, because the trustee can claw it back, or within 1 year if it's a family member. But state law applies in certain aspects in bankruptcy. The look back for a fraudulent transfer under New York law is 6 years. So Peter will be asking those kind of questions of his client. He'll also, you indicated it's your retirement, but is it in a retirement vehicle? So should what right now isn't exempt be made exempt because of that? But that's the value of having someone like Peter who has his head wrapped around, a bankruptcy.
I just, one thing I disagree with what Pat said. Because the farmer runs a very complicated business with no support team generally, I think when you file a Chapter 12, it can increase your income. Unlike what you said, it won't. Because now, instead of putting your fingers in the dike to keep the floods coming in from the creditors, now you can concentrate on planting and on raising your and increasing your income. So I think it can happen because of the 12. It doesn't automatically happen, but I think that is a byproduct.
Well, by paying the value, you've freed up. You're not paying Pat's client $1,000 a month now. You're paying him $750. So you've freed up $250 to help reorganize, for example, if you've crammed down his debt. But one of the sayings in bankruptcy is, it's there, reorganization in bankruptcy is there for a fresh start, not a head start. So it's the honest but unfortunate debtor that gets the benefits that come along with bankruptcy. Because I think today you've learned there's a lot of things you can do with a Chapter 12, and even more so than the other bankruptcies. But the quid pro quo, the pay is you stay current on your taxes, you pay your insurance so that Pat's collateral is protected, you make your payments to the trustee, and you do it all in good faith. And it's one good deed does another kind of thing. Yes, Mark?
I know we're out of time, but I'd like to have, I think, Peter address one more issue and take 5 minutes, and that's taxes. Because there are some very special provisions regarding taxes in Chapter 12.
Chapter 12 only.
I'll take 1 minute and do it, because I don't really understand it all. So if when you're in bankruptcy, you sell off equipment, and you've depreciated that equipment, so it's all capital gains. Now, there is a post-petition, meaning after you filed bankruptcy, tax issue. That is normally a priority. That means it has to be paid in full. It does not get discharged. When the Chapter 12, the people who wrote Chapter 12 in Congress intended that would not be taxable. But there was a Supreme Court case that said it is taxable. Despite what you say you meant, it doesn't say that. So they just passed a change to the law saying that for that kind of situation where you sell something off where there would otherwise be a capital gain that is taxable, that tax will not be a priority. It will be an unsecured tax which is dischargeable in bankruptcy.
So you don't
Only in
have
a
to pay it
Chapter
in
12.
full like you would outside of 12. You can pay it as an unsecured debt, and
So-
that could be anywhere from, 1% or whatever. It's only in Chapter 12.
Thank you.
Thank you.
Thank you.
Thank you very much.